M. St. Charles versus Wagner. This is a parenting time show cause hearing filed by Mr. St. Charles. I'll go around the Zoom boxes as you appear to me. I'll state your name. Please state your names for the record. Ms. Wagner.
Nicole Wagner.
Ms. Boyd.
Sarah Boyd.
And Mr. St. Charles.
Matthew St. Charles.
Ms. Mullen.
Tracy Mullen here on behalf of front of the court.
All right, since this was privately filed, Ms. Boyd, we'll start with you.
Thank you, Your Honor. Mr. St. Charles filed this show cause motion due to alleged violations of the judgment of divorce, which was entered in this case on October 27th, 2022. Most of the alleged violations are regarding respectfulness, essentially some parenting time conditions, as well as a few violations of joint legal custody. I think there may be some confusion as to what joint legal custody entails on the part of the defendant, and I'm hoping that the court can clarify that.
Okay, so Ms. Wagner, what's going on?
From my understanding of what was filed, their supposed violations are that I don't use the parenting app to notify Matthew of appointments, which is false, and I've submitted out all of those. Every appointment that Noah has ever had, Matthew St. Charles has been to, which has been included in that app. Other violations including I denied him parenting time, which he turned in a violation when our son was seen in the emergency room for a seizure. And that was filed in front of the court, and front of the court denied that violation, stating that no violation took place, as well as other violations, including harsh and aggressive language, which has been filed once or twice.
So Mr. St. Charles, what appointments are you alleging that you're not seeing them? Sounds like she's putting them on there.
The ones that I haven't been able to go to were the EEG, which was December 21st, and then the emergency room visits.
Ms. Wagner, did you tell hospital security that Mr. St. Charles, did you file something with hospital security? I saw that in the allegations.
Yes, I did. I contacted them and asked them for my safety and Noah's. They do not allow a third party to be involved. And Matthew and I have an abusive history. Matthew and I, in my opinion, I do not feel comfortable being alone with him because things get very verbally aggressive, as well as then allegations get thrown around of he said, she said, and then this happened several times before. And I asked them, in their opinion, for my safety and for Noah's and to keep everybody at ease, what was the best thing to do. And they told me that because he did not have physical custody, they did not need to allow him in. That was under their policy at the time. And so I told Matthew about the appointment. I told him how it went, and I told him I would give him the results when I got it, which I did. But no, he was not there for that.
Well, you're aware that with joint legal custody, you don't have any authority to keep him from coming to appointments.
Right.
So you did that in violation of the court order?
I did not keep him out of the appointment. I was just asking in regards to everybody's safety.
When would you have been alone with him? It sounds like you would have been there at a hospital.
Yes, but the scan that our son had done, he was attached to the wires to monitor his brain activity, and it was just Noah and I in that room. So it would have been just Matthew and I alone.
So is the solution that we just have Mr. St. Charles take him and you don't take him to the appointments, or are you going to start allowing him to go? You can't just prevent him from going to these. Do you have a PPO in place or anything?
No, I've tried getting one.
And in other words, the courts reviewed it and denied it?
Yes.
So what are we going to do going forward? I mean, we can't continue to have you just block him from doctor's appointments. You don't have, he has joint legal custody.
Correct.
Okay, so you are not permitted, you do not have authority to bar him from going to any appointments. Do you understand that?
Yes.
All right. As far as the language goes, I'm not sure how I'm supposed to enforce that. I mean, it's not something the front of the court usually enforces, but obviously we want the two of you to get along as co-parents for the sake of your child. But moving forward, I hope it's clear, we're not supposed to be barring him from any medical appointments unless the court says otherwise. Understood?
Yes.
All right. Thank you all.
Your Honor, can I just address one other issue very quickly? The court order states that the parties are supposed to be exchanging the minor child at the sheriff's department. The defendant is often demanding that my client either meet her or pick Noah up at her house or drop him off. And when he says, no, I want to meet at the sheriff's department for my safety, that's not taking place. And basically he's threatened with denial of his parenting time if he doesn't pick up and drop off where she wants.
Okay, I did read the order, so we need to be meeting there.
Just to input, there have been very few occasions where I have asked Matthew to drop him off or pick him up at a other location. And that's usually when I have to work. So, and Matthew has never thrown a fit about it. We've always agreed and made that work. Even just over the last week, he had to come up and bring him home. I met him to drop him off, but I had to have him bring him home, and that was not an issue.
It sounds like unless you agree otherwise, you have to be at the sheriff's department on Woodmere, and that's just the way it is.
Correct. And we have always agreed on those occasions where it's been otherwise.
Your Honor, I would say that's not true based on the communications. Just from November through February 22nd, there were, I think, 12 occasions where she requested and required that he pick up and drop off at her home. There was no asking. It was, you have to come here and get him. Otherwise, I guess you don't get parenting time. And the one time my client did push back and said, no, I'll be meeting you at the sheriff's department to exchange him, Miss St. Charles said that she was going to call the cops if he did not drop the minor child off at her home and try and report him for kidnapping.
Well, obviously, we can't do that, Ms. Wagner. So you're going to have some, you cannot deny parenting time based on the exchange if it's supposed to be at Woodmere. I mean, the two of you can still agree otherwise, but it sounds like that's not really what's happening. You're just telling him what to do. So we can't do that. You're not in charge. You have joint legal custody and you've got a judgment of divorce. If you're looking to change the judgment of divorce, that's a totally different thing. But we're not here for that. We're here to enforce the judgment. And I mean, it's sad really that the judgment was entered in October and we're already here for these minor issues that are affecting parenting time in March.
This case is now in arrears only based on a second order modifying order for custody, support, and parenting time signed December 22nd, 2022. That became effective, a zero support order as of December 1st, 2022. And the remaining balance on the account is $492, of which Ms. Boyd is owed $429 in child support and medical support. The remainder is fees. The prior charge on the case for the one child was $429 per month. The last payment made on the account was in November 2022. Mr. Santilli paid $1,287.
That payment was right before our last child support show cause hearing, correct?
This is a new motion, but there was, I believe, previous scheduled enforcement that was resolved prior to any kind of contempt findings, payment plans, or other hearings.
Thank you. Okay, Mr. Santilli, so what's been going on?
I guess I don't understand why the child support was set to zero when the papers that I received said that she would owe me $43 a month. And I mean,
I guess I'm wondering why you haven't paid the $492 is all I'm worried about right now.
Well, because I thought if I got the $43 a month, that after 10 months, that would be almost $492.
In other words, you knew you had to pay, you decided not to pay and violate the court order.
I guess there was just a misunderstanding.
Okay, Ms. Boyd, anything you'd like to add?
No, Your Honor.
All right, so at our last hearing, I did warn you, I knew that I had a feeling this would happen where you just blatantly violate the court order. I'm going to find you in contempt. That $492 needs to be paid by Friday at 5 p.m. or you need to remand yourself to the Leelanau County Jail where you'll have to spend up to 30 days in jail or until it's paid. Understood?
Okay.
Did you say Reinbold? All right, thank you both.
Thank
Yeah,
you.
I turned some paperwork into my caseworker. I did it all online, but I don't know if I got to get a hold of him to see what the holdup is.
Just on changing your name.
Correct.
Okay. Well, I just wanted to call you the right name. It says Mindy Burnham on your screen. So, Mr. Burnham, if you'd state your name for the record, please.
Brian Sean Burnham.
Thank you. Ms. Mullen.
Thank you. Tracy Mullen on behalf of friend of the court. In this matter, it is Mindy Burnham, now known as Reinbold versus Brian Burnham, docket number 2012-009-220-DM. In this case, parties have a first order modifying order for custody, support, and parenting time signed August 18th, 2021, which orders Mr. Burnham to contribute child support and medical support for one child in the amount of $296 per month. We are here as an adjournment. We've been monitoring Mr. Burnham payments on the account since his release from incarceration. He reported new medical issues and was ordered to provide medical documentation as well as any updates on his Social Security disability claim that's, I believe, is on appeal. We do have a document from a treating physician that was provided to our office since the last hearing in February. The current balance owed by Mr. Burnham in this case is $12,273.73, of which $10,724.57 is owed to Ms. Reinbold in child support and medical support. There is medical support owed to the state, fees, and no cost. Payments on the account since our February adjournment, he's paid a total of $150.98 on this case.
Thank you. So, Mr. Burnham, what's been going on?
Well, I found a physician, primary care physician. I started seeing them, and I've been recommended to a neurological specialist and a pain management specialist, and I might have to go to another orthopedic specialist.
And you're seeing those specialists. Is that a part of your Social Security disability claim?
Yeah, and for my primary health care also.
And for your treatment? Okay, sure.
Yeah.
Okay. Is it true that your disability claim is on appeal right now, as Ms. Mullen stated?
Yes, sir, because we had to start over because I missed the court date.
Okay. In other words, at this time, are you able to work, sir?
I'm not supposed to, but I do odds and ends things so I can make some type of payment.
Okay, but have your doctors recommended that you not work?
Yes, sir.
Okay. Ms. Burnham, anything you'd like to add?
Not nothing that I've said before, Your Honor.
Okay. Well, I mean, at this point, I don't know what else what sort of options I have. I mean, the medical professionals have recommended that Mr. Burnham not work. I have to make a finding that he doesn't have the ability to pay, at least at this time. Perhaps some of the treatment will help him physically get better and at some point work. But at this point, I'm going to dismiss the contempt based on the fact that there's no way he can work. I'm not sure what else I can do. Thank you both.
Can I actually have just 1 minute to say something really fast?
I think I'm okay. Thank you. I gave you an opportunity and you said no, so we're all set. Thank
Do
you.
you want to call Mr. Burnham's other case, or do we?
Oh, sure.
I don't know if he's gone now.
No, he's
No,
back.
I'm here.
Oh, you're here.
Yes.
Okay, thank you, Mr. Burnham. Sorry. I thought you were disappeared there. My apologies. Okay, in the second,
No,
thank you.
no, ma'am.
All right.
And I continue to pay what I can. I have no problem with that.
Sure. Let me
I
just-
appreciate that. I know we're going to call your second case. I just with the medical issues, there's nothing I can't really require you to be paying. You've been told not to. I do respect the fact that you're paying, sir. I understand that, but there's no sense in having court for show cause when you medically cannot work. So let's call it a second case, and I guess this is part of the second case since his co-parent isn't here.
Yes, this is a matter of Donna Burnham versus Brian Burnham, docket number 2006. In this case, parties have a judgment of divorce signed April 4th, 2007, which orders Mr. Burnham to contribute child support and health insurance premiums for one child in the amount of $199 per month. Balance on the account in this case is $17,822.49, of which $17,255.49 is owed to Ms. Burnham, and then there are fees. Payments on the account in this case since our February adjournment. In February, we received $103.88, and it appears that $135.59 has posted to the account in this case this month, which I believe might be an offset.
Okay. Sir, anything you'd like to add that we just covered your other case. Anything else you wanted to add to that?
There should be more money than that showing up. That's all.
Okay. I mean, to just to check in, you are paying some amount. Is that correct?
Yes, sir.
And
Yes,
you've
sir.
been told by a medical professional, basically recommended or advised not to work, correct?
Yes, sir. Just like I sent a letter where they said that I'm not supposed to drive or do anything like that. Also,
Right. So I do appreciate the fact that you're paying, but I'm going to also dismiss this one based on the fact that I don't believe he has the ability to pay. He is paying some, but medically he's not supposed to be working. But I would just encourage you, sir, to keep us updated on any medical findings so that we can keep your file current. Okay.
yes, sir. Yes, sir. I want no troubles. I want no troubles. I mean, as y'all know, my past, I've been locked up a lot, and I'm actually trying to get my stuff together and actually provide some type of stuff, mental, physical support for my children, because I know I have failed them in the past.
Okay. Well, thank you, sir.
Thank you, Ms. Burnham.
Yes, ma'am. Yes, sir.